Good day. This is Tshwaraganyo Mmereki, the host of Pitso Podcast, where we use our past to make sense of the present and hopefully shape the future. We talk about the issues from the past, news from yesteryear, the dikgang tsa maloba le maabane. Pitso Podcast today is having a wonderful guest, Mr. Tshiamo Rantao, who is a prominent attorney in Gaborone, managing partner at Rantao Attorneys. Mr. Rantao, you are welcome to the Pitso Podcast.
Hello, Tshwaraganyo.
How are you,
Thank you for inviting me.
It's an honor for us to have you as our guest today.
Thank you.
The reason why we invited you is because we want to talk about the minutes of the Independence Conference, which were held at Marlborough House in the United Kingdom, in England. But before we go any further, I will ask you to introduce yourself, briefly give us a background of your family. From researching for this podcast, I saw a post in your Facebook page where you talked about your family history, that you came from South Africa, the Huruts as refugees, and we are settled in Botswana. So tell us more about that so that we understand, or our viewers know who they are talking to. Yes, sir.
Yes, Tshwaraganyo, thank you for the question. My family came to Botswana, my paternal family came to Botswana and settled in Botswana, arrived in 1960. That's my paternal grandfather and grandmother with their children.
Okay.
My dad and his siblings. My dad is the firstborn. We are the first generation of the Rantaus who were born
in Botswana.
Okay. I was born and bred in Lobatse.
Okay.
But the Rantao family settled in Sakutshwane. Sakutshwane is those are the lands behind Otse village on your way to Lobatse. It's some 9 kilometers, exactly where they settled is some 9 kilometers between from Otse, but between Otse and Ramotswa, next to the South African border.
Just behind Manyalanong Hill.
Yes, just behind Manyalanong Hill.
Okay.
They settled there. They came on foot, crossing the border then in 1960.
Okay.
Fleeing from the apartheid regime.
Okay.
Because the old man, i.e. my grandfather, hated apartheid, particularly Bantu education, with a passion.
Okay.
So he wanted to raise his children, i.e. our parents, uncles, aunts, in Botswana land at the time, in 1960.
Okay.
So the family settled there, never to go back to South Africa. So in 1994, when many went back to South Africa, who had come to Botswana as refugees, they didn't go back. I mean, they were well established in Botswana in 1994, as you would imagine. My father was a catechist in the Roman Catholic Church. He passed on in 2022. His younger brother, Paul Rantao, was a top politician in the country. So there was no going back.
The cream of the cream.
to their place of birth.
Yes.
They were all born in South Africa.
Okay. And in that post that I referred to, where you talk about your family coming here, you refer to a change in the Constitution to deny this uncle of yours. You call it the Rantao clause, if I got it well. What was it about?
Yeah, that's what we were told, especially by academics at the University of Botswana back in the late 90s when we were students and early 2000s.
Okay.
They used to tell us about what they call the Paul Rantao clause.
Yes.
Apparently, sorry. So when you look at the current constitution,
yes,
you qualify to become president of Botswana or to be elected as president of Botswana if you are a citizen of Botswana by birth or descent.
Yes.
Right?
Yes.
The original text of the constitution did not require that you be a citizen of Botswana by birth or descent. It simply said, if you are a citizen of Botswana.
Okay.
So, Paul Rantao obviously was not born in Botswana, was born in South Africa. He became a citizen of Botswana, but he wasn't a citizen of Botswana by birth. He wasn't a citizen of Botswana by descent, because they came from South Africa. So he was therefore excluded by that amendment of 1987, the constitutional amendment of 1987. At the time, Paul Rantao was a rising star in the BNF. He had just become a mayor in 1984. So the amendment was done in 1987, and he was I think, chief of publicity and propaganda in the Botswana National Front, and he was very popular. He was a firebrand. If you remember him and Paul and Maichorlo Dabutas of this world, and Kavindamas of this world. Obviously, those were under Kenneth Koma, Dr. Kenneth Koma. So he was very popular. So we were told that actually that was meant to target him in particular at the time in 1987, so that he could not become president.
Okay.
So that means that Paul Rantao could become president of Botswana, and he was in Botswana in 1966 when Botswana attained independence.
Yes.
Obviously, as a young man, or even a young boy, So from 1966 to 1987, he could become president of Botswana.
Yes.
But from 1987 onwards to this date, I mean, he died in 2005.
Yes.
But if he was still alive, he could still not become president of Botswana now, because that is the current position of provision in the Constitution. You only become president if you are citizen by birth or descent.
So from what you are saying, I get the sense that amendments to the Constitution, some of them are made to target certain individuals or certain tribes to deny them. So the motivation is not always right. I think
certainly yes, the motivation is not always right.
Yes.
Because those who are meant have the power to alter the Constitution can use it to target certain individuals or groups or tribes, as you rightly pointed out.
Yes.
I'm certain that it happens in other countries.
Okay.
You know, that's where you've been having some of the wars around the world. If you dig deep, you might find that it's because of issues like this.
Okay.
Amendments which are not done in good faith, but which have ulterior motives, which are done in bad faith to target specific individuals and or groups of people.
So if I hear you well, would I be right to say that we must always check the motive or the motivation of changing the Constitution or whatever law, whether it like you are saying, is done in bad faith or good faith? Should we have that as a standard or as a measure to sieve whether this amendment is genuine or genuinely want to improve the conditions of Botswana, or it's because we are targeting a certain individual or groups?
Yeah, I guess that's one of the principles. I mean, it has to every amendment, alteration to the Constitution has to be done in good faith.
Yes.
I mean, if it's not done in good faith, it doesn't serve the purpose. It doesn't benefit the nation because of the ulterior motive behind it.
Okay.
And the example that I gave, if it is correct,
yes,
because I haven't seen the Hansard where this was debated, but that is in 1987 when the amendment was made to the provision in the Constitution, Section 34.
What was the motivation of this amendment?
Yes, I haven't seen the evidence. I'm just talking about what we were told back then, and it was mostly, if you remember, Tshwaraganyo, those academics at the university who would have known the motives there, who were grown-ups at the time.
Yes.
That because of maybe the context, because of the surrounding circumstances, one could come to a conclusion, a reasonable conclusion that this was meant to target Paul Rantao at the time.
Okay.
Hopefully history won't repeat itself in that respect.
Yes. Thank you very much for that brief family background and how your uncle contributed to the struggle in Botswana, if I may say so. But today, like I said, we have invited you because we want to talk about the minutes from the Constitutional Conference, where the Constitution of Botswana was adopted. This idea came from a story in the Sunday Standard, which said, Sunday Standard story instrumental in Mutumisi's win. I understand from reading that you represented Mutumisi when he had a case against the former president of the Republic of Botswana. So I want to ask you what this case was about, because similar to the Rantao clause, I think the constitution here was under test. So we need to understand what was happening, the minutes as you read them. But first, talk to us about what the case was about, so that we understand the value of these minutes, how the minutes helped you.
Yes, in 2015, sorry.
Yes.
We were instructed by the Law Society of Botswana.
Yes.
And Mr. Mutumisi, now Judge Mutumisi.
Yes.
But at the time, Mr. Mutumisi, who was a legal practitioner, a senior attorney.
Yes.
He had been chairperson of the Law Society prior to that. To represent the Law Society and Mutumisi challenging the decision of the then President Khama refusing to appoint Mr. Mutumisi as a judge of the High Court as per the advice of the Judicial Service Commission. At the heart of the dispute was interpretation. The interpretation of Section 96(2), subsection 2 of the Constitution, which provides that the President shall appoint a judge of the High Court in accordance with the advice of the Judicial Service Commission. President Khama at the time argued, obviously through the Attorney General, that the advice was of the Judicial Service Commission was not binding on him. It was just advice, and he could reject it. So he rejected, without giving reasons, the recommendation or the advice to appoint Judge Mutumisi. Our argument on the other side was that if one has regard to the language of the Constitution, the language used in Section 96(2), not only the language, the context relating, about respecting judicial independence, separation of powers, and the history of the provision, then the advice is binding. So we argued extensively based on these principles. One, literal interpretation. We said it says in accordance with. What it means literally, in simple English, is that it is binding. But we said even the context, if you look at the need, the constitutional need for an independent judiciary, and so on and so forth, and separation of powers, it's with us, meaning it supports our argument. And lastly, the history of the provision. So in terms of the history of the provision, we needed to dig deep, because the history of the provision, then we have to go into the framers of the Constitution.
So the case was first argued at the High Court?
Yes, it was first argued at the High Court.
Before you saw the minutes, or you read the minutes?
No, affidavits are filed at the High Court, not at the Court of Appeal.
Okay.
It went to the Court of Appeal on appeal.
Okay.
So on appeal, you use the same record that was used at the High Court.
Okay.
But the evidence is placed before the High Court. So the Court of Appeal relies on looks at the same evidence that was used at the High Court by way of affidavits.
So you had the minutes at the High Court?
At the High Court.
Okay.
Before we filed the case, we had to prepare.
Yes.
And we already knew that these are our arguments.
Okay.
But why then did we have to look for the minutes?
Yes.
We looked for the minutes because we could not then talk about the history of the provision for purposes of demonstrating the framer's intention without having regard to the minutes. So we went to the National Library in Botswana, or the National Archives.
National Archives, yes.
There was nothing. We couldn't find the minutes of the conference.
Yes.
Of the 1966 conference, the Botswana Land Independence Conference, which were held in London in 1966.
Okay.
So we, through contacts, managed to obtain them, but after a struggle from the National Archives, the British National Archives in London. So that's how we secured them.
Okay.
But we didn't have to travel because, obviously, the world now is a tennis ball.
Yes.
We used contacts who could get them and
share them with you.
Share them with us. That's really what happened, and then we looked at them.
So you didn't travel there physically?
No, we didn't travel physically.
Okay.
I would, of course, have loved to travel physically.
Yes. Okay.
By that time, I had never been to London, only on transit.
Okay. So
to other countries.
You secured the minutes, and they were part of your
affidavit
at the High Court.
Yes, supporting our case. So we secured the minutes. We argued having regard to the minutes. In fact, what the minutes show, they show that it was common cause that the judges of the High Court, they called them at the time, and that was the initial text of our constitution, puisne judges.
Yes, I remember.
Yes, the wording puisne judges were appointed, in essence, by the Judicial Service Commission. The actual appointment, the letter and all of that, is done by the president. But the president's role is merely ceremonial, in essence. That's what the minutes reflect.
Okay.
So that was our argument. So our argument was therefore that, one, the literal meaning of the provision of Section 96, subsection 2 of the Constitution supports our contention. The context is with us. The framer's intention, the history, is with us. The High Court dismissed our application. We took it on appeal to the Court of Appeal. A full bench of the Court of Appeal agreed with us, 4-1. So 4 justices agreed with us, and 1 judge dissented. Justice Raungwelelwe gave a dissenting opinion.
So from perusing through the minutes, what did you see? What did you experience? I don't know how you are taught. I don't know at law school the Constitution of Botswana. Whether you dig deeper or you just read a section without going into its historical context, knowing the mind of the framers. Do you do that, or you only experience that when you were doing this case? How is the Constitution of Botswana taught?
No, the Constitution of Botswana was, constitutional law. I mean,
it's generally constitutional law. Constitutional
law, I think we were taught.
Okay.
And that's why we applied the framer's intention.
Okay.
Because the framer's intention applies at times, it can be used at times as an aid to construction, also a canon of interpretation of the Constitution. So it is for that reason that we used it.
Okay.
We used the history of the provision to support our argument. So that's one of the ways of supporting one's argument. I.e., you can use the framer's intention. So it came handy because, in fact, 2 justices of appeal on the majority side actually went out of their way to write their views based purely on the history Based amongst other things on the history that we brought to the attention of the court, or we filed with our affidavit, meaning the minutes, the London minutes.
Okay.
The Marlborough House minutes.
Yes.
Yes.
So from what you are saying, I see the value, at least for us laypersons, the value of getting into these historical records to understand how things were and what the original intention of the framers, what were they thinking, so that we don't make assumptions. From that, would you say these minutes are valuable in whatever we are doing to change our constitution or whatever?
They are invaluable.
Invaluable.
Yes, because when you look at the minutes,
yes,
we shouldn't make the mistakes that were made by our forebearers then.
Yes.
When you look at the minutes, you see that there was only 4 representatives of Botswana in the conference.
Okay.
The conference had 9 sittings in February 1966.
It's at 9 times.
9 times, but only in one month.
Okay.
In 1966.
Okay.
We were represented by, at the time, Dr. Tshwaraganyo.
As Prime Minister?
At the time, yes, as Prime Minister.
Yes.
Because we had a Bechuanaland Constitution of 1965 before our Constitution of 1966.
Yes.
We had that's Tshwaraganyo, Dr. Tshwaraganyo. We had PG Matante, Mr. PG Matante. We had
Kwet
Masire.
Yes.
We had Khosi Batwing the second.
Yes.
Only 4.
Only 4.
And there were 4 officials from Bechuanaland.
Okay.
But those officials were not Botswana.
Yes.
They were British nationals, but they were taken as representing us.
Okay.
So only 4 Africans, so to speak, from Botswana, and 4 British individuals representing Botswana. And then on the other side, you had about, at all given, or in most cases, every sitting, you had an average of 11 representatives of Britain.
Okay.
Against our people. So when you take those 11 representatives of Britain and you take the 4 British officials who were from Botswana,
yes,
they were in total 15 out of 4.
Okay.
When you look at all the 9 sittings, that's the average.
So do you think this representation in a way influenced the way the Constitution turned out, or does it have a bearing? Who is present when the Constitution is made? Does it have a bearing? Because I've heard some people arguing that women were not represented, so-and-so was not represented. So if, like you are saying, there were 15 British nationals and only 4 Botswana, do you think that had an impact in how our Constitution is today?
Yes, I mean, it goes without saying. When you look at our Constitution, we've always said that it's a Westminster type style.
Okay.
When you look at the minutes, they tell you that the discussions, they would simply say, for instance, in the discussions, they would agree on a provision simply because it happens within the Commonwealth, other Commonwealth countries.
Oh, okay.
No discussions, no extensive discussions around it. So it was more like a cut and paste of similar constitutions in the Commonwealth, simply because they were under the monarchy, under the Queen.
Okay.
As you say, at least from the Botswana side, there was not a single woman. It wasn't representative of women. No religious representatives. Of course, there was Khosi Batwing the second, the only one from Bokhosi.
And we hear Matante boycotted the meetings. he walked out.
Yeah, but then the problem is they wouldn't reflect on the minutes. I don't see that. Maybe I missed that because I haven't read them like in that sense.
Okay.
But I don't see my reading,
Okay.
which was probably a case I read lens in terms of the nitty-gritties as to who attended and why this one didn't attend.
Okay.
It may well be true that happened. I don't deny that. But the minutes,
Or he was just-
obviously they wouldn't want the minutes that show that.
Okay.
It may well be that the minutes, in fact, the secretariat were all British.
Okay.
So that explains that there was not even a single Botswana in the secretariat. And those were the people who would be taking minutes, making sure that the minutes are reflective of what actually transpired without any, tweaking it, you know.
Okay. I wanted to ask, for example, the American Constitution. My layman's reading. I think all of them were men. The point I'm trying, I just want to dig out from you whether if everybody was male or everybody was female, does that have a bearing on the Constitution? Or when you do a Constitution, there are certain principles that you look at regardless of who was there or not. Can you not have a Constitution that is representative even if not every demographic in the society was represented? I don't know whether my question is making sense.
Yes, it's a very beautiful question.
Yes.
And that question was very clear in one of the most famous cases to ever come from this country, which is internationally acclaimed, which is the Dow case.
Okay.
In the Dow case, it was a question of discrimination, remember? Against women.
Okay.
Right? The Constitution of Botswana didn't provide for this, expressly provide for the word sex in categories which should not be discriminated against under Section 15 of the Constitution.
Okay.
And I think Section 3, but particularly Section 15. The word sex, the Court of Appeal had to read into Section 15.1 the word sex because it was a progressive Court of Appeal back then in 1992, if memory serves me well. The reason why words like that were not excluded may well be that the framers deliberately left them or didn't see them as important at the time. It's a group of men.
Because women were minors.
Yeah. In fact, the Attorney General's main argument was that our society was patriarchal as at the time.
Okay.
And it should be left as such. Says this is how our society is.
Okay.
This is how Botswana are. So the Court of Appeal the High Court and the Court of Appeal should not interfere with our way of life, which is patriarchal. And the argument being that those provisions, Section 15, and so on and so forth in the Constitution, reflect what we are, and they should be left as they are. When they said they reflect what we are as society, it means that those men reflected, those men, 100% men representing us at the conference, wanted that. It should have remained as that.
Okay.
So the Court of Appeal had to be creative, had to be progressive to, interpret that provision to say, even though the word sex
is not there,
we are reading it into because we have to look at this broadly. If we are to breathe life into the Constitution, that the Constitution is a living document. It has to be cared for, nurtured, and it grows with the time. It is a living document.
Okay.
Yeah.
As we draw towards a close, back to the minutes, I think from the Mutumisi case, I see that these minutes can assist at least in understanding what those men who were there, the 15 British nationals and the 4 Botswana, at least what they were thinking, what was going in their mind. when they drafted different, or when they agreed upon different provisions of the Constitution. Given that since last year we've attempted a comprehensive review of the Constitution, do you think these minutes can play a meaningful role, or at least in us understanding what the intention of the framers was as they drafted the Constitution? Do you think we can benefit from them? Do you think we can have educational programs around them so that as the Constitution is discussed, Botswana understand, or here, this is what they were thinking. We don't agree with them, but at least we know what they were thinking. Do you think the minutes can be useful in that way?
Yes, if we are to understand, properly review our Constitution,
yes,
as a nation,
yes,
there's obviously debates around the country around that, around very difficult questions.
yes,
and whether or not Botswana really understand the Constitution, and that maybe there's need for public education of the nation. You know, if we are to meaningfully amend the Constitution, there has to be that understanding. I remember that Khosi Mosadi, I think Khosi Mosadi said that in the House of Chiefs about public education around the Constitution. And I don't think she's the only one. I think there are people who continue saying that it's very important, because if you do not understand the document that we are talking about, how can we then amend it? And the historical background in that public education is important. We have to know where we come from. We have to understand our past if we are to shape our future.
Yeah, that is the purpose of this podcast.
Yeah.
Yes.
That is what I think Siraja Khama said about our past is very important. He says, is it a nation without a past?
Yeah.
It's a lost nation.
It's a nation without a soul.
It's a nation without a soul. Thanks for correcting me.
Yes.
So, public education cannot be done without the historical background, without teaching people what the framers' intention was. If the framers' intention was bad, let the people understand.
Yes.
And you can not teach the historical background without availing the minutes to the public, because these minutes are in the National Archives of the British, of a library in London. They are not in our national library, unless if they subsequently came after we discovered our case.
They are not yet there. I checked at the National Archives. They don't have the minutes. I think I checked even for the Lobatsa conference. They are not there. So that leads me to another question of repatriation of our archives. Is it something that is worth advocating for, that we need to our documents back so that we understand what happened before we shape whatever future we want for ourselves? Is it repatriation of archives? Because I hear some of them are in Zimbabwe. I think it's Harare, former Salisbury, and others are in London, some are in Mafikeng, like Sechele's canon, where the canon that Sechele used to defeat the Boers in 1835. Yeah. It's not in Botswana. So all these materials, do you think it's a worthy cause to advocate for them to come back, so that, fortunately for you, you had contacts outside, you were able to get the minutes, but for us, mortal beings, ordinary citizens who don't have contacts all over, so that I can just walk across and get to the archives. Yeah. And do you think it's something worthy, before we even want to talk about changing the Constitution, just to understand our history, the archives coming back? Do you think it's something important?
Yeah, obviously. I mean, that's our history. That's part and parcel of us, our history. So it's important that our libraries have all of these records. I don't think anybody can argue against that. So interestingly, these minutes for the Bechuanaland Independence Conference,
Yes.
the document is headed, this document is the property of Her Britannic Majesty's government.
They are not our property.
Yes, this document that I have in front of me is not Botswana property. It's property of Her Britannic Majesty's government. So I don't think it's impossible to get at least copies. There may well be originals, but that's obviously government to government. Botswana is, my understanding, a nice relationship with Britain, its former protectorate.
Yes, yes.
Sorry, its former protector. So I don't think that should be an issue at all. I think it's a question of governments liaising and making sure that they do the needful in having our records updated with all this history, which those who come after us need to have regard to. The students and everyone else need to have access to and to speak to.
Thank you, Mr. Rantao. Do you have any last words before we close? For me, I appreciate your time. I believe I'll still be inviting you in the future to discuss the challenging issues that we talked about around the Constitution. Now, we just wanted to focus on the minutes and their value and how they assisted you and how even the Court of Appeal appreciated that this document can help in interpreting certain provisions of our Constitution. Do you have any last words?
Thank you for inviting me, and I really enjoyed the program because it was something that I'm passionate about, the Constitution, So, and the fact that I'm actually surprised that we still don't have these minutes as part of our records. If we visit the National Archives, we won't find them.
Yes.
One hopes that the officials at the National Archives will do the needful, because we got this in 2015. This was in 2015. We filed them in 2015 on the 21st of October 2015 at the High Court.
So it's 11 years later.
So 11 years later, as you said, we still don't have them. But as I said, and I think as you said, they're important in shaping our discourse around constitutional amendments. In fact, quite interestingly, this conference was for purposes of considering Bechuanaland's proposed amendments of the then Bechuanaland Constitution for purposes of independence. They said, we want to be independent. We have this Bechuanaland Constitution. We need these amendments. Yes.
Okay.
It came from Bechuanaland, but obviously dominated by the British, who were officials here, who were part of that conference. The one that I said, the four of them.
Maybe one last thing from what you just said. If you listen to some people talking, you get a sense that most people are not aware that there was a constitutional conference in Lubate. So part of this episode is educational, for people to know that we started here, made proposals and went to London with those proposals. So that it's not like everything was shoved down our throats. At least there was some discussion of some sort, though limited as it is, as some people would say. So I want to thank you that as we bring up these issues, people will become aware that we had a constitution. You said it's 1965 constitution, which we took to London as a proposal.
Yes, it was called, to be specific, it was called Bechuanaland Protectorate, in brackets, Constitution Orders, 1965.
Okay.
That was the constitution at the time. Statutory instrument, 1965, numbers 134 and 1718 came into effect on the 3rd of March 1965. So we had some form of some constitution there. And they say this constitution granted to the country, I mean Botswana land.
Yes.
This constitution granted to the country to form a responsible government. So they gave it to us at the time in 1965 to form a responsible government. That's these are our subjects, form a responsible government.
Mr. Rantao, thank you very much for your time. I hope to see you again in the future.
Thank you, sir.
So that we discuss these matters and educate the public. Thank you very much, sir.
Thank you.
Thank you for watching the Pitso Podcast. Don't forget to like, share, and subscribe. Thank you very much.